Commissioner Woods has a
I wanted to ask you, is it Tom?
Yes.
Under the ordinance section 6852 found on the staff report 2-12, it talks about non-conforming issues and the solution with those that are in operation today. And I'm a little troubled by the date and the extension to 2013. What's your legal opinion and the room that we have to work within that issue?
Well, I think the issue that I was hearing raised was that if anything was established during the moratorium period, as to if it would be allowed under the non-conforming use period. My understanding is the use had to be legally started under the terms of this provision. And anything that was started during a period in which there was a moratorium preventing it from being begun would not qualify.
So therefore, if we interpret that, if a dispensary opened up during the moratorium and was in a legal site based on the ordinance, then they could continue.
No, because anything that operated during the moratorium or was begun in the moratorium period would be per se illegal because there was a.
So therefore, that's where the statute here or the issue here in section 6852 says they got until 2013.
No, they wouldn't have any time.
Right.
They have to be out now. They're illegal from the start.
Right.
So they don't have any amortization
Well,
period.
then educate me about what this section means then. Perhaps Joe is.
Yeah. Commissioner Woods, so what the section means is that if there were any medical marijuana facilities that were established before the moratorium went into effect, that they would have 3 years from the effective date of this ordinance to basically run their course and come into conformance.
Would that be, do they also have to be a legal in conformance with the ordinance as it stands today?
No,
To have that time frame, or?
no. They could continue to operate for that, it's that basically that
So if we have
it's a 3 year
if we
grace
have a
period.
dispensary, within 100 foot of a school that was done before the ordinance took place, they get to stay until 2013?
Correct.
They're considered a pre-existing non-conforming use.
And then
So by
after,
definition legally, are our hands tied there?
Yes.
And as a follow-up to that question, as we're looking at areas that potentially this would be allowed in the county via zoning, does staff have a number of what those legal non-conforming dispensaries would be at this point?
Through the chair, Commissioner Norgan, I'm aware of one in the Spring Valley area.
Okay, and for clarity, we're referring to the unincorporated area.
Correct.
Thank you.
staff continue.
Thank you, Chairman Brooks. Just to go over some of these other issues that had come up.
Mr. Faraci, Mr. Chairman, with your indulgence, I wanted to follow up on that signage thing. I'm not quite sure I understand. For example, on the when we had the winery ordinance before us 2 weeks ago, there was a lot of discussion on the signs size. So we could still, by ordinance, restrict the size of the sign, not the content. Is that the issue?
My analysis would be yes, you could restrict the size but not the content. And if you've got similar size restrictions that would apply to other kinds of businesses, certainly you could do that within a legitimate time, place, and manner restriction. Yes.
It would fall right into a regular signage ordinance that we have with respect to a given zone.
It very well may, yes. And that would be perfectly
I don't know
legal.
if that helps or not, but okay, thank you very much, I appreciate it. Thank you, Mr. Chairman, for letting me interrupt.
Chairman Brooks, just quickly going through this list. Just some clarification again. Chairman Brooks, did I say Woods? I'm sorry.
Pardon me, I was distracted.
Oh, no problem.
Did you guys need
To quickly go through this list, one of the issues that was brought up, just for clarification on the available sites. So what this map here represents is is the available industrial zone properties within the unincorporated county. In terms of safe access and access, if you can see just by their proximity, they're located in what would probably be considered the more populated portions of the county. So they are located within the more populous areas and would provide access to those areas. There are a couple, there is one site in Borrego and one site in Campo that was identified that are zoned industrial and happen to meet the buffer requirements. In terms of the buffer requirement, distinction that I wanted to make is that we have a buffer requirement from residentially zoned properties, not residential uses or residential homes. So it's not as onerous as it sounds. The commission is very familiar that much of our county is zoned A70 and A72, which is essentially a residential zone to be used primarily for residential. So I wanted to keep that, make sure that we're aware of that.
Agriculture with dwelling units.
Correct. In terms of the time for the ordinance, we had this ordinance, we did it on an exemption. There's no obligation or no requirement that we had this go out for public review, but we did. We did put it out for a 30-day public review period. We posted it to our DPLU Advanced Planning website. We put it on our Twitter page. We also sent out some hard copies of the ordinances for public review to individuals who expressed some interest. There was, as the testimony stated, there was increased knowledge of what we're doing towards the end of the public review period. That said, the people that I spoke to is that yes, we'd like it to end on this day for the sake of being able to move this item forward to the Planning Commission. However, there's no hard and fast deadline for you to submit, and they could have submitted past that deadline, and I expressed that to them, so they could have done that. The visibility issue from the street, we want to retain that there was a comment made that there should be no visibility from the street. We want to retain that there be some visibility from the street. We think it would make it safer if people, if access to and from these facilities could be viewed from a public roadway. In terms of the CEQA issues, we reviewed the state law, we reviewed the CEQA requirements, and those were vetted through our county counsel's office. And we do feel that the sections that we've cited in CEQA can apply, the exemption sections. Those deal with section 15061B3. We felt that we could apply that section since what this ordinance was doing was attempting to adhere to and implement the Compassionate Use Act. And then we also felt that 15308 of the CEQA guidelines could be applied since that requirement is for the protection of the environment, and these regulations would continue to promote public health, safety, and welfare. So we thought that that was applicable in this section, in this instance also.